Okay, thank you. Now I'm back. So just before we begin, maybe somebody can tell me how's your week been? How's class been so far? How's the ATP program? Have you submitted your project work? And then also, I heard that they wanted to postpone your oral exams. How's that so far? How is that going? Maybe before we begin the next 5 minutes, somebody can just bring me up to speed.
Hi, Solonka. This is Linda. So I think yeah.
Go on, Linda.
So maybe correct. My week has been pretty okay. We are holding up with the classes and everything. Our projects are not yet due. They should be due towards the end of October, and the orals. Not really that they were trying to push them. It's it's us who felt like we needed more time, so we just did a proposal, but we've not received any feedback from the school. Yeah, so that's about us. Yeah.
Oh, that's nice. That's nice. My week has been good. And the pupillage is also doing well. And yeah, that's it about me. Learning a lot. I'm really learning a lot. So I say that's a class. Now, orals, do you like, okay, Linda, for you, are you prepared? Do you think you're prepared?
Well, I wouldn't necessarily say that I'm prepared, but I think if they came, I'd be able to handle them. But I definitely voted to have them postponed.
That's fine. That's fine. That's fine. Okay, now I'm seeing a majority of the people have joined. We are 109 now. Okay, so let's begin with the pupillage application and how you should go about it. So the advice I have for you is start applying as early as now so that you avoid being locked out. Right now, I have friends who have not gotten pupillage yet, and it's kind of worrying if let's say you've done the exam and you don't have a place to go, you'll start panicking. So the biggest advice is start applying as early as now. Start applying to various law firms. Don't have all your arrows in one. No, apply to different places and broadly. So, for instance, for me, I applied to firms. I applied to Amai and Allen, the firm where I'm in right now, by Allen Wayaki Kishui. I also applied to I applied to DLA and I applied to Oraro. I don't remember well. Okay. But the farm which I applied to and I really was interested in going was in Wamai and Allen. And I'll give you the experience I had when I was applying to that farm. So we applied, sent our documents. They usually do the applications via there's an online portal, their website. So I did the applications, sent my documentation. So the first stage is, they sieve the documents, sieve the people, and then now come up with a group of guys who they will interview. Now this depends with law firm to law firm. So depends with various law firms. For instance, for us, there are two interviews we did. We did an oral interview, which was basically just an orals exam because I had to stand there and I was questioned by two advocates and the HR officer. Actually, the HR officer was the only person who didn't ask me legal questions. So the two advocates were asking plainly and purely legal questions. So, I was asked, what's the derivative action? What's the difference between tenancy in common and joint tenancy? Something to do with tax. So I was asked something to do with tax and so forth. So that was the first stage of the interview, oral interviews. So after the oral interviews, those who performed well move on to the next stage. And the next stage is now the written interviews, which we did for a whole 3 hours. So they sent us a paper and they told us to answer within 3 hours and then we submit it back. Now the written interview was basically an exam and I will project my screen on some of the sample answers that I gave. So the first question I remember, we were told to draft a defense and counterclaim. There was something to do with drafting an opening statement. There's just a wide array of questions. There are around 6 questions which you are told to answer. That's what happened to me. So whenever you're applying for pupillage, you need to know the law firm first of all, know what you want, and know what you want to practice. So, for instance, at Wama and Allen, they do a lot of corporate commercial and commercial litigation. Allen Gishui is the former LSK president. Is a very, very good commercial litigator, and that's why I chose to go there. Now, somebody else might want to venture into family matters. Look for a firm that is suited or a firm that does such work. If you want to practice criminal law, look for a firm that engages or does criminal law, or even go to the DPP's office, or even the AG's office and so forth. But if it depends on what you want. So gear your applications towards what you want. And this is only possible if you start right now, because if later on you haven't applied and you start doing it in a rush, what will happen is you will not be able to, you will not have the luxury of choosing where you want to go. You will just pick any firm that you want to, any firm that will give you an opportunity, that will actually just accept to give you some desk space. So that's the thing. Start applying as early as now and start preparing. It depends on the firm. Some firms ask you legal questions. Others will not ask you legal questions. Others you will have like 3-stage interviews. Others you will have 2-stage. Because I'm not sure about. Some of my friends told me they did aptitude tests. So there are others which will give you subject you to aptitude tests. So you also need to prepare for that. If it's orals, they will ask you oral questions. So you need to prepare so as to do it. So as to manage to get a spot. Remember, you're applying to a place whereby I'm so sure you'll apply to, let's say, for example, you apply to firm X. Other than you who's applied, you will find over 300 people have also applied to the same firm. Yeah? And that comes to the next key pointer. How do you make your applications? Many guys requested me or asked me about how my cover letters and CV was, or resume. Try as much as possible to restrict your resume or CV to at least 1 page, as much as possible. 1 page. If it goes, if you have so much to write about, limit it to 2 pages. That's the advice I can give you. So after you've limited it to 2 pages, you also need to draft a cover letter. Make sure you do a cover letter, do a research on the firm and what areas of practice they do. Just try to pimp up your cover letter. Avoid small erroneous mistakes such as spelling mistakes and so forth. Yeah, and hopefully all will be well. Now, that's the thing. Personally, and in my opinion, law firms are the best place for you to begin with when you're doing your pupillage application. But then that depends with you also. For me, I think it's easy. It's easier to transition from a law firm into the corporate practice than from corporate practice into a law firm. So if you can and if you will, take a good law firm, apply to a good law firm, make sure that they have a lot of work. Yes, just don't go there and you're being told to. I don't know if you guys on Twitter some few weeks ago, guys were complaining about being told to go cook, being sent to do house hunting for their bosses and all. That's not part of the page. Sorry, I broke off. Can you hear me? Hello, can you hear me? Oh, sorry. Okay.
Yes, sir.
Okay. So try to get a firm which will make you gain experience and do a lot of legal work. You have 6 months, learn as much as you can from there, and then afterwards plan your life accordingly. At the same time, if you feel like you want to enter into government, there's the office of the AG, it's also very busy. There's the office of the DPP, it's also very busy. I don't know that. I think KRA is also there. There's KRA and there's RB. If you want to practice tax, apply to KRA. Just whenever you're doing applications, gear it towards something that you'd want to practice in the future, or somewhere that you will really, really, really learn. You have 6 months. Make sure you learn as much as possible in those 6 months. And your pupillage center determines a lot. It will determine the kind of lawyer you will be. because you learn a lot from your pupillage master. If you go to a place whereby you don't have that much exposure, it will have some kind of bearing in your legal practice in the future. So I think that's some of the few words I have for you when you're doing your pupillage application. I don't know how you want us to go about this. Do you have any questions for me with regards to all pupillage so far? Feel free. Oh yeah, and about CVs, if you want to draft a good CV, let me just project my screen for a few minutes and show you something. Okay. Okay. Fidel, go on.
Good evening, sir.
Good evening, Fidel. How are you?
I'm fine. I hope my question had not been answered in a previous meeting because this is my first time here. But
yeah, please go on.
So about applying for the pupillage, when you say, for example, those wishing to join government to do a government job, for example, are we supposed to wait until applications are called for? Or, for example, if I wanted to apply to the office of the DPP, for example, am I supposed to wait until they are called out? Or how do I go about finding vacancies? In short, I think I want to ask, how do I find vacant places? Do I just wait until they are called out, or how do I go about it?
Oh, thank you for your question. Now, for government offices, for instance, the AG and the DPP, they usually announce. They'll give an advert and tell people to apply. That's for those offices. Applying before, I'm also sure, but I can give an instance. For example, PSC announced that they were taking Parliament. Parliament announced that they were taking pupils. They gave their first announcement, I think 2 months ago, then gave a second announcement 2 months ago. But there's been some sort of delay because they haven't called the pupils yet. And that has a bearing because, for me, I started my pupillage in May. And if you're waiting for PSC to make that announcement and, maybe to vet and do interviews, up to date, they've never done any of them. So people who are waiting, let's say they announce on, okay, let's say this month, okay, let's say next month. It means you'll be starting a pupillage in October, count 6 months from October. Yeah? It kind of delays you. That's why I didn't I'm not so much inclined towards government offices, but yeah, that's the problem with it. You have to wait for them to announce. From the experience I've had last year, the AG's office announced, the DPP's office put an advert. KRA, I'm not so sure, but I've seen people in KRA. I'll ask how they went about it. But yeah, that's how it went. So you'll have to announce. Unlike law firms where you can just walk in. Now there are certain law firms where you have to wait for them to. Okay, they usually announce. There's Oraro announces. Anjawala usually announces. Okay, these top tier firms, they usually announce. So for them, you have to wait for that window for you to apply. But there are other firms, good firms, whereby they don't announce, but you maybe meet the advocate, create a rapport with them, and you get work. So it all depends. But for government offices, they do announce.
Thank you, sir.
Okay, karibu sana. Who else is raising their hand? Kenneth, please go on.
Okay, thank you. So, drafting CV, do you include referees or do you just say to be provided upon request?
Oh, in the resume.
Yeah.
Okay. Let me just share the one I applied with. Resume. Let me just. Are you okay with me sharing mine? I can project the screen. Huh?
Yeah, that's okay.
Okay, let me just share it. Okay. I have so many tabs open. Yeah, so this is the one I used to apply. And just try to see how you could fit your materials in. So for instance, this is one page and it has all the crucial information that's needed, all the crucial information. So I have this is my educational background, my work experience, in brief. Remember, it's just brief. You're just pointing them towards what you've done. If they need further clarification, they'd contact you. The thing is, remember, these people have or get over 300 applications. Yeah, over. Most of these top tier firms. There is only maybe 2, 3, 4, 5 at most, maybe 6 people who will be perusing your application. So the issue is how many, like, do they have time to go through all those CVs? You know, maybe you've done 5 pages, you've done 6, they won't have time. But if you have one main, one page resume where it's captured everything, all the things that you, you know, all the things, your educational background, your work experience, your training and certification, everything, and referees. You asked about referees. I've included them here in my on this on the far left corner. Yeah. So this is the resume I used. So the question is, do you know how? Would you want to know, or maybe to learn how I made that one?
Yeah.
I just show you in brief of how I went about it. I just did just come to Word, Microsoft Word. So this is Microsoft Word, yeah. Just come to File over here, and then open. Let me just see. Usually somewhere here. Export. Yeah, here, new. So you've opened Word. There is a new over there. So you just come to resume and cover letters. So for me, just took one template here and I modified it. So I just took one, just any random one. You just take any random template and then modify it to your liking. So for instance, I can pick, let me pick one that I did pick. Let me pick, you'll just pick random one. There are so many. And you see my, I need to update my Word. Let me just pick it. Let me just pick it. So from here, you just modify it. You put it to your liking. Yeah? And it's free. You don't need to hire somebody to make your resume for you. It's free. Takes at most 1 hour of your time, and you're good to go. Yeah. So do you have any further questions with regards to that? I hope you've learned how to go about it. Was that helpful?
Yeah, that's okay.
Okay, I can see Dece. Dece has a question.
Yes, Mr. Salonka. With regards to what you are teaching us right now, what happens when a person does not have work experience?
Oh, there's no need. You're doing pupillage. They don't expect you to have work experience, so don't pressure yourself about that. Don't pressure yourself about that.
Sorry, I have seen firms which actually, if you don't have any sort of background in working, they just disregard you completely.
I think that's wrong. That's wrong. Because even for me, if you see my work experience over there, it's how can I put it? I would just put judicial attachment, or else, yeah, and clinical externships. So where I studied in my undergrad, it was compulsory for you to do clinical externships. In clinical externships, you have to look for a government office or a private company. So I went to the Ministry of Environment, and that's what is in my CV. Other than that, I didn't have any other prior work experience. So that shouldn't make you feel like you won't be selected to join a firm. But if there are firms that are doing that, I don't think that's fair, because you just finished campus and you went into the Kenya School of Law. There is no, what kind of work experience surely will you have gotten within that time frame? Is that okay?
Okay.
But give it a shot. Give it a shot.
Okay.
Give it a shot. Hi,
It's okay.
local. Yeah. Okay. Local, Mary, please go on.
Hi, good evening.
Good evening.
There are rumors I heard that if one has like second lower, like it's kind of tricky for one to assign a place in a law firm for pupillage. It's kind of disadvantageous.
You find out?
It's kind of disadvantageous. The majority of the guys who are out and who haven't yet attained the position is because they have second class lower in their
Okay. Okay. Yeah, I get it. I get it. Yeah, that's a sad reality. Some farms, but I can say some, not all. And by saying some, I'm talking of maybe 1-2% of the farms, maybe the top tier farms. They even look at grades, high school grades and all. But at the same time, that shouldn't, because I know a friend of mine who didn't get a second class upper, but she's in one of these top tier farms, like one of the top tier, the biggest in the country. So don't be, don't what's the word to it? Don't be what? Don't be discouraged. Just try your best, try your luck, and apply. You never know. Yes, you may not have gotten the second class upper or first class upper or a first class degree, but maybe you have something in your CV that is particular to that firm that attracts you to that firm. So give it a shot. Give it a shot. I actually know of somebody who had a first class, but getting a farm was a bit difficult. So, but the thing is, the moral of the story is, even if you had a first class, that doesn't assure you of a place. And even if you had a pass, that doesn't mean you would get a law firm to go to. Or maybe, actually, if you check the KSL website, there are so many other institutions other than the law firms where you can go to. It says that I have a liking towards firms because you gain more exposure and more experience to it compared to starting off in corporate. But at the same time, it depends with the person and it depends with what you want. Yeah, so don't be discouraged at all. Who else has another question? Hi, Deche, go on.
Yeah. How? To what extent would you recommend international commission on commission or committee on jurists, the Kenyan one? How good is it for one to undertake pupillage they are considering? They have a background in international law.
Okay. Is it an approved center?
Yes, it is an approved center. I've seen it in the list given by the school on the website.
Okay. Now, what I can say is, if you love international stuff, you want to practice international law, go for it. Apply it. You'll gain better international experience there than compared to a firm. That's a fact. Yeah? So if you want to practice, if you want to be a litigator, for instance, you want to practice litigation, go to a firm that does a lot of litigation. If you want to practice international law, go to a firm that does a lot of international, or an institution that does a lot of international matters. That's the advice I can give. So if it's there, and okay, to be honest, I haven't heard of it. This is the first time I'm hearing about it. So if it's there and it has a lot of it has the potential of giving you exposure to international matters, apply to it. I'd advise that.
Okay, thank you.
Karibu sana. Welcome. Who else? I'd seen a hand that was raised up and then lowered. Dego, go on.
Yeah, thank you. Is Omai and Allen offering any opportunities for pupils for next year? Might you know?
Yes. They do it annually. So for me and my mates, the guys who the other pupils, our pupillage is coming to an end in November. I think November or early December. I'm not wrong. Yeah, so it's coming to an end. So they usually advertise. You can check the website, and I think they are open right now, and if it's not open anytime from now, it will be open. Yes, they are offering. They take pupils every year. They take pupils every year.
So thank
Karibu sana. I'm seeing somebody has typed a question on what goes into the cover letter. So the cover letter bit. So the cover letter is just you, how can I say, in Waniki's word, you tell a story, but the story is about yourself. So you have to introduce yourself, who you are, your background, educational background, work experience, if you have any work experience. Have you done any other courses other than your degree courses? So, this is where, see, maybe you do not have a first class or a second class upper, but other than your low degree, you have a CPA, you have a CPAS, you have a what? You've done some international certifications, you've done some taxation trainings, you've done some financial, something of a sort. Those can get you into what? Into these top tier firms. So yeah, that's where you put it, you explain it, yeah? And then maybe in brief, just give what do you expect, not what you expect from them, but what you want to do in the future, and so on. And keep it as short, 1 page at most, 1 page at most. So that's what a cover letter entails. It's just a story, but the story is about yourself. Yeah. Masibo, please go on. Masibo, please go on.
Good evening.
Evening.
I was having a difficulty in unmuting. So
It's okay.
my question is, okay, there is this rumor or a story I've heard from especially our seniors. You normally say that you'll be much when you'll be much more exposed when you work in the so-called a smaller law firm than these big tier law firms, because I don't know them, there's specialization, so you won't be exposed as much as these lower firms whereby they deal with everything. Is it true or is it just rumors? Because anyway, what is your opinion about it?
Okay, thank you for that question. So yeah, to some extent it's true. To some extent is okay, yeah, it's basically true. But at the same time, you can't refute the kind of exposure that you get from big firms. Now, for example, Bowman's or maybe Triple OK or maybe a DLA Pipe. You'll find that they have so many departments, yeah. Now you'll find that the kind of exposure you will get there, you won't get in a smaller firm, because they handle a lot of, for instance, mergers and acquisitions, international mergers. So you may be there for the 6 months, but then the transactions you handle are they're kind of it's a top tier transactions, very high value transaction. Yeah. But at the same time, the concerns are that you may not really gain the exposure. Like, okay, unless they do retain you, chances of you going back. To be honest, not better place. I can to give that kind of opinion, but I'll get a friend of mine who's gone to maybe Bowman's or Triple OK or such, and then they give their advice. But personally, I can give from my own point of view, from where I am. I can say that the kind of exposure I've gotten in litigation is I don't think many people have gotten. I don't think many people have gotten that kind of exposure, because in 3 months, okay, I shifted departments after 3 months. I started in the commercial litigation department. In those 3 months, I've gone to the High Court. I've done a matter that is in the High Court. I've done a matter that is in the Court of Appeal. I've also done a matter that is in the Supreme Court. And I've also done an international arbitration matter in Singapore, a Singapore arbitration matter. I drafted the notice of arbitration, the request for appointment of an arbitrator, and so forth. You see, that kind of exposure is good, even if it's for a limited amount of, like for those 3 months that I've gained. At come, I didn't go deep into it. That kind of exposure is good. But at the same time, the small law firms, the kind of exposure they get you is you will be given and you will handle everything. So you will handle, for instance, criminal matters, you will handle civil matters. You will be told to go to the registry. You will learn how the registries operate. You will do conveyancing transactions. You will do so. That kind of exposure also plays a long way in your legal career. Also, when you begin, because when you begin, you will know the ropes of these things. Compared to somebody who, compared to somebody, compared to somebody who did, compared to somebody who just went into a certain department, he was just there looking at, something like that, something of the sort. So I can say both areas will give you the kind of exposure. It all depends on you and how much you're able or how much you're willing to learn for those few months you're there. Yeah. And then the legal practice right now is gearing towards specialization. So it's a good thing. It's a good thing. Is that okay, Masibo? Ama, do I need to clarify any?
It is okay. It is okay. But finally, just a small thing before I
Yeah.
go. Then there is there's someone who told me that the main reason why we have problems, especially in Nairobi, you see, Nairobi is saturated with let me not saturation, like a lot of students when they finish they want to do their pupillage in Nairobi. So someone was advising me that if you find it hard, like when you're applying in Nairobi, you can apply to these upcountry law firms, because even some of them don't have pupils, because most of students want to do their pupillage in urban centers. So okay, that's just an advice that I was given. So I don't know if it suffices or it was a wrong one.
That's a very good. It's a key pointer. Actually, it goes back to the essence of devolution. Devolution was to take Nairobi's to those small areas. Kajiado should have a very very big, vibrant, running economy, same as Machakos, same as Mombasa is very huge. The other counties, Uasin and so forth. But that's not the case. Upcountry farms, yes, you will be assured of work there and all, but then you need to gauge and look at the type of work that will be coming your way. The kind of transactions that happen in Nairobi are different from the kind of transactions that happen in upcountry. In Nairobi, you will get very complex charges. You will be told to draft, if you work in the conveyancing department, prepare a very complex charge involving, there's a head company, there's a management company, there's a bank, there's a purchaser now, so forth. Complex transactions. Such transactions will happen you'll find them in either Nairobi, Mombasa, these major hubs. So the kind of exposure you will get in Nairobi is a bit different from those that you will get in upcountry. But at the same time, it boils down to what you want to do and what you want to practice. I've not been to the upcountry farms, and I'm not so sure, but I'm not so sure about how they run or go about their business. But Nairobi, the kind of exposure you will get in Nairobi, the practice in Nairobi is very different from practice that is maybe in Nanyuki, from practice that is in Loitoktok, from practice that is in Kajiado, and so forth. Whereas you go to Kajiado, limited to the kind of transactions, maybe it's family matter, criminal matters, kidogo hapo, so forth. But if you want to practice in the commercial arena, you're doing debentures, you're doing commercial agreements, joint venture agreements, mergers and acquisitions, you'll find those things in Nairobi. You won't get them. You won't get them up country, and that's the thing. It will be very hard for you to transition from that kind of background to the Nairobi background. It will be a bit difficult for you. But if you started, let's say, from Nairobi, and then you're like, Nairobi is not working for me, let me go and do it, and let me go and open my practice in upcountry, it will be a bit easier for you. But see, if you've spent much of your legal practice there, and then you come and transition here, you'll be limited to the kind of briefs you'll be getting. And that's why I'm saying for the 6 months, try to, as much as possible, learn everything that is possible. Everything. everything I need, atakaa nikuguzia kidogo, so that afterwards you may know what you want to do and then go towards it. That's fine, huh?
Oh, that's fine.
Okay, karibu sana. Okay, who else has a question? I can see Mercy has typed. Can you talk about firms asking for recommendation letters and testimonials? I'm not so sure. I never applied, or I've never applied to a firm that asked for a recommendation letter or a testimonial. But if they do, you can just get maybe a former lecturer or somebody who's, okay, so not somebody who's close, but somebody who you've worked with to maybe provide a recommendation. That's the advice I can give. But at the same time, I think it's highly unnecessary for a firm to be asking for a recommendation letter, and the position you're applying to is a pupillage position. It's seriously unnecessary. You know, the objective of pupillage is you're not getting employed there. They are training you. It's like some sort of giving back. It's a training. So they should welcome you the way you are and mold you and train you to produce a very good advocate. That's the essence of pupillage. And this is what is wrong with the legal profession right now. They take pupillage as a form of employment or as a form of, like you just labor, you're providing free labor or, just free labor or labor for extremely minimal wages. That's not the case. It's training. You're there to be trained. Is that fine, Waruru, Mary?
Yes, that's fair.
Okay. Do you have any question before we proceed? Arunga Michael, please go on.
You are invited for an interview and maybe you're asked pay. How should you go about it?
Yeah, that's a tricky question. Yeah, that's a tricky question. You have been called for an interview?
If you have been called for an interview, then they ask you, do you expect us to pay you? And if you say yes, how much?
And if you say yes, how much? And that's usually a very tricky question, according to me personally, because you see, there are two ways you can go about it. You can mention a very, very high figure, and your employer will be like, hapo nayo, to be honest, I can't afford it. And then you mention a very low figure, and you know what your employer, you mention the low figure, and they're like, okay, so we'll pay you, and then you get yourself work whereby you're being underpaid. And at the same time, you cannot mention both, because you see, give or take, Arunga, you're an employer. You've asked your interviewee how much they expect, and they say between 20,000 and 30,000. As an employer, what you've had is 20,000. You've not had 30,000. You've had 20,000. So the smart way about approaching it is, to be honest, I don't have an answer about that. I won't even lie. I don't know how we'll approach it. I'll have to go watch YouTube videos on that. Like blunt, honest. If I was asked that question or maybe surprised, I will just say, what will I say? Because you can't say in between. I think there's a way you have to play. I have no answer for that. I honestly have no answer for that. I'll go do research on that and then get back to you. I'll ask my employers on Monday what they expect. Yes, Kimani. Kimani.
I'm sorry, I have any issue.
Yeah.
Mine was really not a question. I think when you just mentioned you're going to ask your employers how to go about the question, then that's fine. But probably to shed more light on what my colleagues have asked is, there are very many tutorials on LinkedIn on how to answer that question. First of all, do not give a range. That's the thing they always tell everyone. From like the HR specialist, they always say don't give a range of salary, because as you said, your potential employer is going to take the lowest figure that you have given. So give something exact, and then talk about probably one, why you think that you're worth that kind of money, and also say that upon doing your research on people or job descriptions that have the same, jobs that have the same description as yours, and also pertaining to what your job description would have you do, then you feel like that is worth the money you would be paid. So essentially, just don't give a range, and also don't go for too extreme. Just do your research and ask, like, look at how much interns are paid, probably interns of equal tier to the law firm you've applied to, because you cannot expect that pupils from Bowmans will be paid the same as pupils from, a law firm that is just probably based in the rural areas. They always have different ranges. So just do your research and probably even ask around how much people are paid in that exact law firm. And then, just like you said, maneuver is the answer. Don't give an exact, like a range of, just avoid the ranges. Whatever you do, just avoid them. Yeah.
Thank you for that. You see, now you've educated me. I've literally gained a lot from you, and I really appreciate that. I'll go watch those. If you can, please share them in the group. I'll actually go watch them. Thank you so much, sister. Wandabusi Edwin, please go on.
Yeah, I like what Esther has explained. However, my experience with law firms is very interesting, because there is no absolute guarantee with those with giving those ranges or even giving the exact figure. And unfortunately, it's again, you will think that you are you're giving the exact amount, and therefore probably that's what they'll give you, until they slap such a figure in your face. You'll be surprised. I had an experience with a law firm where we thought it ought to be quite, not really not top tier law firm, but again not that cheap. Is in Nairobi, actually right in the CBD of Nairobi. And when we went there with my friend, we went through the interview process, and we were actually taken in, and we were asked for how much we would like to be paid. And in our wisdom and ambition, or lack of it thereof, we dropped our figures there but only when we were given the contracts to sign, and this guy had pure peanuts. Anastasia seems to be leaving the law firm right now.
Go on.
All right. So we were surprised when the figures came for our salary. Actually, it is you can't even describe it as peanuts. So what I must tell my colleagues is that with law firms, there are those top tier law firms, and they know some that are coming up quite well, and they will treat you with respect as an intern. But I must also warn you to be prepared to go to law firms which you otherwise had so high regard of and respect for the lawyers, until they tell you that, in fact, I'm giving you as you are an intern, I'm training you. You are supposed to be the one paying me and not the other way around. And they will say that with a straight face, and only give you some stipend. Actually, we were never paid salary. We used to be given stipend, because at the end of the month, you are given a bahasha. We were not, so that then the advocate avoids paying any taxes and any deductions like NHIF and NSSF and stuff like that. So basically, we are being paid like even worse than our Wochi. So yeah, I don't know. Maybe things have changed, but I must warn you. Then something else you mentioned earlier on the requirements for the questions of second lower and second upper. There's some institutions that are quite strict. Like, for example, I know of Parliament. Parliament is a bit strict on the requirement for at least a second upper. for you to be considered. And basically, if when they are sieving through the applications, they look at those qualifications. So you will not even get an opportunity to be considered because they see they look at the qualifications on the certificate, your university certificate, and put you aside. So some institutions are a bit strict on the requirements, but like, I agree again with Brian that really many times you find that what you got second upper, second lower, or first class sometimes never really applies in real life. And if you are given equal opportunity, chances are you'll whoever got even second low will be as competitive. Thank you.
Thanks a lot for that insight. Thanks a lot for that insight. Yeah, actually, there are firms which pay you in, they call them experience points. It's not even experience, they're paying you in experience, which I think is really, really unfair. But yeah, that's the way. Hopefully, when you open your own farms and you get your own places, you treat our interns and maybe pupils better. Yeah. So, any other question before we proceed? Okay, now I'll just take a few minutes. Our time has gone. Then I'll introduce this basic. Okay, pretty gone.
Sorry.
No, it's fine. Go on.
Yes, allow me to ask, or to clarify something kindly, and it's on the difference between attestation and witnessing. I find, and this is based on our project work conveyancing, and I feel like
sorry, the difference between
attestation and witnessing, and because for me I feel like they're kind of related or the same, because if you look at the definition of attestation, it refers to witnessing of a signature, whereas witnessing, it's of course witnessing of the signature of the vendor or the purchaser. Because the question, the project question indicated that the advocate who witnessed the sale agreement for the purchaser didn't have a current practicing certificate. So I was wondering, I'm wondering whether I'm supposed to insinuate like this was attestation or witnessing, or can you kindly advise kindly?
Okay, I think the question is to make it brief. Is witnessing the same as attestation? Yeah.
Yes. Yeah, that is my question.
When it comes to contracts. Okay. Now, to answer your question, I don't know if you have your Land Act over there, but if you have, or even you can Google it, and your colleagues also, you can check Section 38 of the Land Act, and also check Section Section 3 of the Law of Contract Act. Okay, Contract Act. Yeah, let me just check my Kenya law. Section 3 provides for those provisions. Let me just Kenya law. But if anybody gets it, please feel free to participate, because it's some form of a discussion. So let's participate in Law of Contract Act Section 3, read together with the Section 38 of the Land Act. Section 38 of the Land Act. Then I will explain some of those concepts in brief. Has anybody found contract?
Yes.
Law of Contract. Which one do you have?
It provides no suit upon a contract or disposition of an interest in land unless the contract is in writing, signed by all the parties, and the signature has been attested to by a witness who was present when the contract was signed by such parties. However, this requirement does not apply to a contract made in the course of public auction. And of the same provision have been contained in section. Sorry?
I didn't get you well. Go on.
Well, I'm saying, however, the section 3, subsection 3 of the law of contract provides that, however, these requirements shall not apply to a contract where made in the course of a public auction. And the same provision have been contained in section 38(1). So the requirement of section 3 are in section are contained in section 38(1).
Exactly. Now, that's the what? How can I say it? Those are the legal provisions with regards to contracts being needed to be in writing, contracts for the sale of land to be in writing and signed and properly attested. So attestation from section 38 right together with section 3 of the Law of Contract Act, attestation is basically just witnessing. Yeah. Attestation is just witnessing. According to my, not according to my, it's the law from section 38 of the law of section 38 of the Land Act and section 3 of the Law of Contract Act. Now, if you read that provision, just repeat the one that you talked about, section 38. No suit shall be brought upon a contract. It has to be in writing, signed by all parties, and then attested by a witness who was present when the contract was being signed. So that attestation is just basically witnessing. And that becomes that brings us to another concept. Okay, before I go to the other concept of the one that I want to introduce under section 45 of the LRA, you have to look at that issue of section 3(1) of the Law of Contract Act, and the reason why those by public auction don't qualify. You'll come to learn about it. So there are ways in which you can go about selling, other ways other than entering into a contract for sale of disposition of, disposing land. And it includes how you can structure such transactions. There's the issue to do with leases. They sell by public auction. They had issues with subleases, the section of property, and so forth. We'll come to learn those later on. When you get there, maybe you need a clarification. We can do it with you guys. But attestation is basically just witnessing. And that comes to the next concept of, unfortunately, I don't have my acts here, but you could please check the law of the Land Registration Act. The Land Registration Act, section 45, the aspect of verification. Maturi, do you have your, it's something that I'm interested. I don't know if you'll be taught, but hopefully you will. Actually, I think you will. But those are some of the essential, how can I say it? Yeah, some of the essentials that you use in contract law, starting from section 43, 44, 45, and 46, are valid instrument. But I don't want you to read right now, but you'll go check it out. There is something known as execution, there is verification, and there is attestation. Zinafuatana. Execution is 43. Execution is 44. If I'm not wrong, but you'll confirm. Execution is 44. Verification is 45. And then lastly, attestation. Not attestation, sorry. Stamping. It's supposed to be stamping. Stamping is section 46. 44, 45, 46. Execution, verification, and stamping.
Yes, Mr. Salonka, maybe to ask a follow-up question. Thank you.
Yes.
Who qualifies to attest to such a document? Can any person, maybe an adult of sound mind, attest, or it has to be done by an advocate?
Okay. Then, that's a good question. Now, you have to note the difference, and I'd like you to read section. I'd like you to read section. I think section 45 is a bit not section. Just read the headings. Read the headings in section 44 of the Land Registration Act, and then read section 38, and then from there we distinguish those two documentation there. Please, if you can do just the headings. You don't need to read everything in deep. We could start maybe with section. Okay, let's do 44. What are they talking about? 44, 45, 46. there is a wording. It's kind of different from section 38 of the Land Act. But in brief, maybe you've not got it, maybe you're not there. But section 38 talks about section 38 of the Land Act talks about contracts. And then section 45, 44, and 46 talk about instruments. Now, before I answer you, my question is, what's the difference between those contracts and instruments? What's the question? If you're in Ayera's class, I'm sure he's asked you that question. What's the difference between a contract or a deed and an instrument? What's the difference between those two? Because if you read 44, 45, 46, they're talking about instruments. But if you read section 38, they're talking about what? They're talking about contracts or deeds. Arunga, you want to try?
Section 44, 45.
Okay, that's fine. I just read the headings, the short titles of those provisions.
44, executions of instruments in writing.
Exactly. 45, instruments.
Verification of execution.
But they're talking about instruments nonetheless, yeah?
Yes. Then
46. 46 is?
Stamping.
Yes, stamping. So for those three, they're talking about instruments. But if you read section 38, it's talking about contracts. Muturi just read it out, contracts. So somebody attempted, I saw somebody who had raised his hand up. Odur, please go on. What's the difference between the instrument and those contracts and deeds?
Can you hear me?
Yes, I can hear you very well. Thank you.
So this is the difference. The sale agreement is the contract. It has the terms. It states the terms of the conveyancing, the terms under which the relationship has been created. The instrument, which can be, of course, a deed or a transfer, and the transfer is under LRA 33, are the instrument effect the transfer. When the instrument is registered, then the property is transferred from one person to the other person. But the sale agreement just states the terms, the terms under which the conveyancing process will be done. So what is being registered at the land registry is the instrument. When the transfer or the deed is registered at the when the transfer or the deed is registered at the land registry, then we have, land is changing hands. We have disposition at that level, but the sale agreement is just the contract. It just have it only contains the terms of the contract and nothing else. It doesn't affect transfer.
Thank you for that. Thank you for that. Really appreciate that one. I'm seeing somebody else has a hand. Let's give them a chance. Waruiru, George.
Hey, Brian, how are you?
I'm fine, thank you. Fine, thank you.
Yes. So I want to attempt the question, the difference between an instrument and and a contract. So the best way to explain it is that a contract is simply stating the obligations of the parties. Yeah. Like what are the default clauses in the event you default? Like tutadunini, are we like going to rescind the contract? Are you going to pay interest? Yeah. Basically states the obligations of the parties. That's a contract. For an instrument, it shows the transfer of the proprietor, this word always pisses me off. The rights, the proprietor, okay, I can write it down. So you know what I mean. The proprietary rights, it's just the transfer of rights from one person to the other, from the transferor to the transferee. That's how I can best describe it. Yeah, thank you.
You are actually very, very correct. You guys have gotten it extremely. You're very correct. Very correct. Yeah. Perfect. I have nothing else to add to that. Maybe, okay, Arunga, do you You want to have seen your hand is raised.
Yes, what
you
say,
you
simple by saying the document is in a prescribed form, but the contract is not in a prescribed form.
That's very true. That's very true. You know, just to sum it up, what my colleagues are saying is, you see, a contract just establishes the contractual obligation. Yes, you will enter into a sale agreement, but that sale agreement will not convey, will not pass that title or pass that property to you unless you do what? You register a transfer document. Unless you register a transfer document. Yeah. Can you hear me all?
Yes, you can.
Yes.
Yeah, unless you unless you register a transfer document. And I'll show you how a transfer document looks like. Remember the first meeting we had, I told you guys to go read specific documents. I told you to go, when it comes to conveyancing, read some specific things. Read the LSK conditions of sale, read legal notice number 278, read legal notice number 280, read legal notice number 277, and you're good to go in that paper. You'll seriously pass conveyancing. Let me just open it up. Just open it up. So this is legal notice number 278. Yeah. So you know the contract. Let's start with me showing you the instrument. So when they talk about instruments, this is what they talk about. I'll open a transfer instrument. So legal notice number 278 only has a few. Okay, the substantive pages are up to page 30 something. So it's something you can do at a size before you go sleep. You can do it in 1 hour and you'll be done reading legal notice number 278. Because it begins here from page 1 up to page 35. That's all. Yeah. Yeah. Yeah, that's all. Now, Arunga asked a very important question. Who can witness? Who can verify? Who can engage in those matters? And the answer is here. Verification of instruments. Now, an instrument. Let me first describe that instrument. Let me open LRA 33. All these are instruments. All these are forms. So the legal notice number 278 has 196 pages, but the substantive bit is only what? The substantive bit is only 35 pages or so. The others are just prescribed forms, as Arunga talked about. So this is from LRA. Yeah, this is a transfer. Now this is an instrument. We begin from there. This is an instrument. This is how it looks like. Transferor, transferee, the transfer of interest in land. In witness, the transferors and the transferees have signed this transfer as a deed. So this is the execution bit. This is where these people executed. Now there's the verification. Remember the verification we talked about in section 45. This is a verification. Now to answer Arunga's question, who can do it? Who can verify? It's up there. In the fourth schedule. Here, instruments executed in Kenya. Who are the people who can verify it? A person qualified or practicing as an advocate, a judge, magistrate or kadhi, registrar or deputy registrar of the High Court, a registrar, or superintendent of prisons. Those are the only persons. But this applies to instruments alone. When it comes to contracts, attestation, they don't have any classification of who can. They don't have any classification of who can attest or witness. And for me, I think anybody can do it. So you will have to go read the Advocates Act. This is the Advocates Act here. Unqualified persons don't to prepare certain documents. So you need to read this act and then come up with a conclusive answer. No unqualified person shall either directly or indirectly take instructions to draw or prepare any instrument and any document relating to the conveyancing of property. So you're seeing the issue here is preparing, but you're attesting, you're not preparing anything. Anybody can attest a contract. But when it comes to verification, there's a limited class of persons pursuant to legal notice number 278. Has that been answered sufficiently? Now the difference between you've seen maybe you could type in the chat box if you've understood what an instrument is and how they look like as I open, just type yes or no as I open a contract of sale of land or a sale agreement. Yeah, I found a sale agreement. Let me just open it up. So this is a sale agreement. So you think the sale, this is just a normal contract. It establishes contractual obligation. But the document that transfers the title from you to the other person is a transfer instrument. Now it's an instrument under the legal notice number 278. I hope that's clear. With who can do it and who cannot do it, and what the difference is, what is the difference between a contract and an instrument. And it's actually a question that is asked by conveyancing lecturers in class. So Muturi, are you satisfied with the answer? Then we go to Odor. Odor, your hand is up.
Yes, thank you.
Okay, Odor, please go on.
Again, thank you so much. Mr. Solonka, I think maybe there's a clarification that we need to make in relation to execution. And I think that's where Muturi's question is coming from. I'd like to bring it to your attention that Muturi is talking about I'm of the opinion that what Muturi is talking about is under section 44 3 that says that the execution of any instrument referred to in subsection 1 by a corporate body, association, cooperative, society, or other organization shall be effected in accordance with this provision, that is the Land Act, and in the absence of any provisions, the execution shall be effected in the presence of either an advocate of the High Court of Kenya, a magistrate, a judge, or a notary public. I think the execution that he's talking about is under that section, and why the purchaser in that transaction, the conveyancing question that we have is a corporate body. So where we have a corporate body, then I think we must have an advocate. It must be signed in the presence of an advocate. That is my opinion. I think that is what is bringing the difference between whether it can be signed by anyone else or whether it must be signed in the presence of an advocate. I'm of the idea that what 44.3 is saying that if it involves a corporate body, an association, or an organization, then it must be signed in the presence of an advocate of the High Court, a magistrate, a judge, or a notary public. So for me, I think that is what is bringing the difference here.
Okay, now I get it. But you know, we go back to the question. Are they talking about a contract or are they talking about instruments? The wording of, please repeat the wording of section 44.3.
44.3 talks about 44.3 talks about execution of instruments in writing.
Exactly.
Yeah.
And now Muturi was asking, what about a normal contract? Does it necessarily have to be the attestation? Does it necessarily have to be an advocate? That's something food for thought. Okay, to be honest, like most sale agreements I've done, it's before an advocates do it. But then asking, will it be invalidated? Bear in mind that you will have some contracts entered into, ushago and all, they enter into an agreement, so forth. In writing one page, imeandikwa haraka, and then, maybe there's no advocate who's witnessed that thing. Will it be valid or invalid? Will that contract be held to be valid? Maybe just
Is this my question?
No, anybody
can. Okay. All right. So if you look at the Land Registration Act, when the Land Registration Act is defining instrument, it says that when it uses the word instrument, it means any writing, including an enactment that creates or affects legal or equitable rights, any covenant or conditions expressed in an instrument or implied in an instrument, any variation of an instrument except where otherwise provided. So I think that if you look at the meaning under A, which says any writing, including an enactment that creates or affects legal or equitable rights or liabilities, I think the Land Registration Act is extending the meaning of an instrument to sale agreements. It is my opinion. I could be wrong. It is my opinion that it is extending it to sale agreements when it says any writing.
Contracts.
Yes. So that's why I think in 44 they are making that difference. If you have a sale agreement and it involves a corporation or an association or an organization, then you have to sign it in the presence of an advocate, only in those circumstances. Of course, it says if they're just persons, then you don't have to have an advocate. That's what it's saying in 44, if it is just between persons. So I think because of that definition, it expands the meaning to not just instruments which are prescribed, but to also sale agreements, my opinion.
That's actually a very good observation, to be honest. Yeah, like, because they've said any writing. Yeah, I'm actually straight to that. And to be honest, as I just said a few minutes ago, all the agreements I've seen, advocates are the ones who witnessed those documents. Yeah. Okay. Yeah, I agree. I tend to agree with that regard. So according to the LRA, they're providing for any writings which contracts can fall under it. Oh, thanks for that. Kimani?
I also wanted to add something else. When it comes to attestation, okay, from how I think there was a previous class that our lecturer talked about this. When it comes to attestation of anything, a document or a contract, usually attestation is like evidence, like how can I explain it? It's the act of witnessing the signing of a formal document. So when it comes to witnessing versus attestation, witnessing, you simply there and you sign whatever, it's you sign to the contract. But attestation, you sign to the contract and then provide a formal, I think it's called an attestation certificate or something like that provides that this document is actually valid and that you were there when the parties were signing and blah blah blah. So he said that when it comes to attestation, it creates a more, how can I say this? I don't know how to use the word, sorry. A stronger backing to the sale agreement as opposed to witnessing, because ideally anyone can witness any document. And then also when it comes to witnessing, to attestation, if that will, that document was attested by someone who declares that they were not, who declared that they were an advocate and they attested to it, and the contents of how the parties signed the contract were valid, and then he happens not to have a practicing license, because that's the question that's the question that's there. It still does not invalidate the contract. But what happens is the advocate is the one who's going to face disciplinary actions, but the document will still be valid. And I still think you guys talked about it last time. If I'm not wrong, it was Patrick or someone who said that.
Yeah, the case of Anaj and Wilson Dolwa, yeah.
Yes.
The issue of, those two case laws.
Yes. So ideally, it does not invalidate the contract, but the advocates will face disciplinary actions. I think that was what was there. I think, Andrew, maybe I didn't answer your question, but I just wanted to add that part.
Yeah. Actually agree with you. So advocates, preparing advocates. Okay, I'll go check, but as it stands right now, all the sale agreements that I've come across, I even checked the template this one was provided to us by Mr. Ayera. It provides for witnessing down there, like, just being present when the document is being signed, and therefore to indicate the correct date in which it was attested and so forth, witnessing. So yeah, reading it by the case law that you guys have produced, Anaj and also Ndolo, also section 34 of the Advocates Act. Yeah, witnessing, I could say, yeah, an advocate. But the same wording invalidate the documents. But then, what's the wording of section 34? Because you've raised another issue of, is it witnessing or is it preparing, Esther?
The difference was between witnessing and attestation. Let me check. I think Daniel's
The wording of section 34.
It was of the LRA.
No, of the Advocates Act. Is it talking about preparing documentation, or what is it talking about?
Thessalonica?
Yeah.
It's talking about preparing a conveyance. So conveyance is first like a transfer.
Please come again. I can't hear you very well.
I'm saying it talk about preparing a conveyance. So my understanding a conveyance is like a transfer or a charge, a lease. But now for a sale agreement, I don't know whether, although I start guided, I don't think it falls under a conveyance or that definition of a conveyance. And actually the confusion, the reason why I was a bit confused is because I have experienced a situation where parties draft their sale agreement and they look for a witness who witnessed the sale agreement, and when there was a default, so they came to the firm for that sale agreement. And you see, in that scenario, the witnessing is done by someone who is not an advocate, and that agreement was enforceable, and the vendor got a redress from court. Okay.
Was it enforceable or not enforceable?
It was enforceable. The vendor was able to recover the value of the purchase price. So that's why I was a bit confused, because we are told the advocate witnessed. We are not told like he attested. He witnessed, and to my understanding, attestation is the stamping where you stamp. So it means for you to attest, you have to be you must be an advocate. You must have a practicing certificate. But this guy witnessed, so it's like a normal witness or someone else who is not an advocate witnessing to the sale agreement. So for me, I understand you don't have to. The fact that he doesn't have a practicing certificate, he qualifies as a witness for that sale agreement.
Sorry, I was talking and I was muted. Sorry about that. So for me, in my opinion, because there are so many contracts, the essential validities of a contract, offer, acceptance, and so forth, all those essential validities, read together with Section 3 of the Law of Contract Act, read together with Section 38 of the Land Act, talking about normal contracts and attestation. And Section 38, I really need to look at it. I don't have my act here, but let me try and get it from Kenya law. I'll need to look at it to see the wording of that Section 44.3, Section 44.3, Section 44.3. Because who was reading it, Odwar? Because when they talk about instruments, and they also brought about the issue of corporate entities or bodies and so forth. When Odwar was reading it, I was noted down corporate. Was it Odwar?
Yes, sir. It was me.
Oh, what was the wording? Please just read it verbatim for Section 44.
Okay, but could I first maybe ask for clarification?
Okay, that's fine.
I don't know what you think, Mr. Solonka, but is it proper when Esther Kimani says that there's a difference between attestation and witnessing under the Act?
No, attestation is the same and witnessing.
Yeah, I think it is the same thing. Yeah, we cannot separate the two of them. Then again, when you talk of Ndolo Aya and Anaj warehousing, did they have the same judgment?
They are not the same, because that was an issue of preparing. That's what I was talking about. Are they talking about witnessing or are they talking about preparing? Because the issue in them was preparing. Yeah? Like it was a draft. Is it?
Yeah. This other one is talking about attestation. The one that we're dealing with is talking about attestation. And the reason as to why it's coming in is because of 44.3 that we've talked about. You've said that I read 44.3 again.
Yeah, please kindly read it.
Yeah. Just a few minutes. I have it here.
Okay.
Yeah. So 44.3. So as we agreed before, yes, the heading is on instruments, attestation of instruments. So it is
execution.
saying
Is it attestation or execution?
Execution. Yeah, executions of instruments in writing. So it's saying it is connected to 1. So I have to read 1 then 3. So 1 is saying, except as otherwise provided in this act, every instrument affecting any disposition under this act shall be executed by each of the parties consenting to it in accordance with the provision of this section. So there it is talking about each parties. Now, if you look at 44.3, it is saying the execution of any instrument referred to in section 1 by a corporate body, association, cooperative society, or other organization shall be effected in accordance with the provisions of the relevant applicable law
up to the applicable law. And I think this is one of the reasons why they're bringing this is because of execution when it comes to companies. I can't remember the section very well, but in companies, there were recent amendments that were brought forth by the Business Laws Amendment Act where they removed issues to do with the common seal. But before, the position was when you're executing, there are various ways in which a company can execute a document. One director in the presence of a witness, 2 directors, a fixation of the common seal. That was before, but there were some amendments that were brought in to remove the issue to be the common seal and so forth. So I think up to there, they're talking about relevant with the provisions of the relevant applicable law. So for instance, if it's a corporate body and it's a company, they're saying you'll have to go back to what? The Companies Act and see how companies will properly execute a document. Up to there, is that Adur?
Yeah, up to there.
That makes sense.
I continue reading.
Yeah, please go on.
Okay, so it's saying, and in the absence of provisions on execution of instruments, the execution shall be effected in the presence. Yeah, in the absence of provisions on execution of instruments, the execution shall be effected in the presence of either an advocate of the High Court, a magistrate, a judge, or and I think it can neither be a corporate body, but what if it is not a corporate body? It will be an association, if not a cooperative society. Yeah. Yes. So in those instances where we don't have a provision that is providing for what is supposed to be done, then I think that is when we have it has to be done in the presence of an advocate. Yes, and that is what is in that question.
That is what he was asking. Yes, that's I tend to agree with that. So when they're talking about that, what they're saying is, like just to recraft that position, provision, what they're saying is, okay, when you're executing these instruments, if it's a company, go back to the Companies Act, check the Companies Act. What does it provide for when it comes to execution? Section 37. Just open my notes. Section 37 of the Companies Act. A document is executed by a company if, the issue to do the common seal was amended. So you'll have to check that. To authorize signatories, a director in the presence of a witness who attests the signature, blah, 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 and so forth. So that's the thing. The Companies Act provides for how it's supposed to be executed. Yes. But then it goes on ahead and says, if the Companies Act did not provide for the same, what will happen? Well, what will be the recourse? The recourse is signing it in the presence of who? An advocate, a magistrate, a judge, or a notary public. And it's limited to certain classes, corporate bodies, association, cooperative societies, and so forth. So I think also this one is kind of different from the aspect of, can anybody witness a contract for sale? Personally, in my opinion, I think anyone can. But according to section 44.3, it's actually different. It's a different provision because it provides for corporate bodies. It provides for what? Corporate bodies. It provides for For what else? Okay, there's corporate bodies. So you mentioned association.
Associations, yeah.
Association and cooperative societies and organizations. So they're talking about like some form of entities, some form of corporate entities, saying, okay, they are relevant applicable laws. A corporate body, for instance, what are we talking about? We're talking about a company. How does execution or executing a company doc, how does it happen? They refer you to the Companies Act. Go to the Companies Act and check how execution happens. Okay? And if there's no provision on the execution of those instruments or documentation and all, the execution shall be done in the presence of an advocate of the High Court, a magistrate, a judge, or a notary public. So you're getting the difference, the different provisions between these and 44.3 and Section 3 and Section 38 of the Land Act. Odur.
The reason as to why I brought it in was just to explain why the question is there and why the advocate was there.
Oh, that is this project work question. Huh?
Yeah, I felt like you aren't understanding why the advocate was there. That's why I talked about 44.3, so that you're able to answer the question promptly.
Okay. Is it satisfactory now? Is it okay?
Yeah, I think now, now that you've explained, I mean, now that we understand the reason as to why the advocate was there, I think now the issue is whether, now if this advocate is here and this advocate doesn't have a current practicing certificate, would that invalidate that that contract, or what would happen in the event that it is not a company and we can't get any applicable law anywhere else and the advocate is there, but this advocate doesn't have a current practicing certificate? So in our conveyancing project work is that's now the position. What would happen? Does it affect the instrument? I mean, does it affect the contract? I mean, it doesn't. So maybe that's the question that you can answer.
Okay. So from the project work, it's a corporate entity, an association, cooperative society, etc. Yes.
They call it something purchasers something. I don't know if it's a company or it is an association. They haven't really indicated yet.
They haven't indicated. Were they preparing or was it just attestation?
Because the purchaser, which is that association or an organization, I'm not sure, was present, then the advocate was in the document was signed in the presence of that advocate who does not have a recent practicing certificate. So does it mean that the instrument, the contract has, can it be used or not?
Then you ask the question, if the issue is on the PC, is an advocate and is qualified, then we'll have to go back to those case laws. And I'll be guided by, I'll have to read that project question again, but I'll be guided as of now. I'll be guided by the case of this thing, the case of the two cases, Anaj read together with Musondola, yeah, and then also check the Advocates Act section 34. I will argue along those lines because I think the lecturer is trying to test that. I may twist so many things, but I think they're going back to that particular point. So that's how I will go about it. But I'll check that. I'll check that question. Okay, how do then Deche?
Okay, so I was just wondering, yes, the Ndolo Aya case and the Najwa housing dealt with unqualified advocate. And how would you know whether someone is unqualified advocate or not? So I think it takes us to Section 9 of the Advocates Act, which says that for someone to be a qualified advocate, then he must have a current or a practicing certificate that is in force, right?
Yes.
Yeah, that is what it's saying. Then if you look at 31, Section 31 of the same act, not 34, because 34 is talking about preparation, and here we were not preparing. They're talking about someone acting as an advocate. Yeah, and they're saying for you to act as an advocate, you must be qualified. So this person was not qualified. He was unqualified to act as an advocate. So I think that's the gist of it. He was not qualified. So I'm thinking what you can say is that, for example, what they said in Anajua housing, is it the duty? I mean, I feel like the reasoning can support us here. Is it the duty of the public to ensure, the rationale, is it the duty of the public to ensure that every time you meet an advocate, you know that they have a certificate practicing certificate or not? I mean, I think they were very clear. They said it is not their duty.
It's not
So
their
is it
duty,
my
yeah.
duty? Yeah, is it my duty to ensure that the person who is there, the person who is saying that is an advocate and is present when I'm signing this contract that involves a company has a recent practicing certificate or not? Is it my duty? Of course it is not. And that's why for me, I think that the instrument or the contract will still be valid because of that rationale. Yeah.
Because now actually I will just be guided by those case laws. The ratio decidendi.
Yeah, exactly.
Like it won't invalidate, but what they said is the advocate will face what? Disciplinary action. So the documents will be valid, the advocate will face disciplinary action. Now the issue is if that person is not an advocate in the first place, then the document will be invalid.
Yeah.
Yeah, thanks for that.
Now, Mr. Sloan, one last question on this. One question on this. The question didn't specify whether these are the same advocate is the one who drafted the sale agreement. The question only mentioned that he witnessed. So it doesn't mention whether there was even attestation afterwards. He witnessed and then there is an attestation that happened after he witnessed. So there are those facts that are not disclosed in the question. So of course the agreement, the sale agreement is valid. And also this advocate should not face any disciplinary action because he was acting as a witness. So he was just witnessing and not attesting. So I feel there's a difference between attesting and witnessing in that there is if you are not an advocate, you'll be deemed as witnessing. But if you are an advocate, you'll be said to be attesting. So I feel like there are those two differences.
Now you see the project work. So they're like, the facts that I'm getting are halfway. I'll have to check that project work. Then now I'll have to go back to it again. Yeah. I'll have to read that thing. I'll have to read that question. But then on the issue of attestation and witnessing, you check the land act. It's the land act, the land act section 38. Who read it? The signature of which party signing has been attested to by a witness. Has been attested to by a witness. Attested to by a witness. In my opinion, there is no difference between, it doesn't distinguish attestation and it's the same thing. That signature has been attested, and nimeiona as a witness. I have attested to you signing. I have witnessed to you signing. Okay, it's the problem of plain English and all. They should have, been a bit more plainer. But in my opinion, I think attestation and witness, it's basically the same thing. If you read Section 3 of the Law of Contract Act. Now the issue will be: are you attesting a contract? Are you attesting an instrument? Right? Okay, not even attesting. When it comes to instruments, there is an aspect of verification. They don't talk about attestation. They talk about verification. If you read Section 45, and there are certain class of people who are allowed to verify, not everyone. And now that one is a bit closed. It's a bit closed now. Maybe now we can have, time is going, we can have Deche, then we have Edwin, and then we have Nyabio. Nyabio, you answered that question just a few minutes ago, but okay, nonetheless, we'll repeat it in brief. So Deche, Edwin, and I can see Nyabio is asking, what is the difference between attestation and witnessing and instrument and sale agreement? Maybe you could ask the questions as somebody else will name. Okay, I'll address the question by Nyabio. Go on, Deche.
Hello, can you hear me?
Yes, I can hear you.
I think we are approaching this question and missing some aspects. As Daniel pointed out, the purchaser was actually a company known as Express Purchasers Limited. And then the person who is purported to have been witnessing the sale agreement They have used the term lawyer, not advocate. So now, Solonka, I would like you to tell me what is the difference between an advocate and a lawyer? Because if you keep using the word advocate and the teacher or the lecturer had another intention by using the word lawyer, we wouldn't be actually approaching this question wrongly, because I'm pretty sure there's a very big difference between an advocate and a lawyer. So the issue of even having a practicing certificate becomes secondary unless and until you determine in what intention or in what vein the teacher used the word lawyer. Because I'm pretty sure if the teacher never meant an advocate, as everybody's using that term, then this becomes an unqualified person, even if it's not just in the aspect of preparing, but he won't just be considered as an ordinary person. And as you mentioned, witnessing, it ought to be differentiated from the aspect of attestation. So can we just first go back and look at the very words used? If you'll allow me, Salonka, I would like to read that very last few lines. It says, on conducting further due diligence, your firm discovered that the lawyer who witnessed the sale agreement for Express Purchases Limited does not have a current practicing certificate, and Karotasi estate agents are not registered estate agents. So the estate agents part is no problem. Let's look at the wordings used there. Is there any difference between a lawyer and an advocate? Let's start from there, please.
Yes, there's a difference between an advocate and a lawyer. So you see, for you, you're a lawyer. I'm also a lawyer, but I'm not an advocate yet. Because for you to become an advocate, go on.
If the word is a lawyer, then the issue of practicing certificate does not come, because this person is not even allowed to have a practicing certificate because you're not yet admitted to to the role of advocate, right?
That's true. That's true.
Then this person, if he's witnessing, then it does not pose any problem at all, because he just witnessed. He never prepared, neither did he attest.
And that's where now just to sum it up, I'll point you guys to where you need to look at, where you need to do your focus your research on. The first thing, if you have a pen, you can write it. Check out the difference in the wording between Section 38 of the Land Act, Section 3 of the Law of Contract Act, and Section 44 of the Land Registration Act. Yeah, that's a first place to check. Now, after you've done that, check what's the difference between a contract and an instrument. And Oduor raised a very good point. He raised a very, very valid point when he was talking about they've defined under the LRA an instrument, something in writing and so forth, can also fall under the category of an instrument. But then please go check Section 44. From what Oduor read, Section 44 is first of all limited to certain factors. Yeah? And it's not touching on attestation whatsoever. It's not touching on attestation that is the attestation that is talked about in section 38. It's talking about circumstances where the execution of documents by corporate entities is not provided for in the applicable law. That's what Section 44.3 talks about. Yeah? And then you'll also have to read case laws, because you'll have to check case laws on it, on the validities of contracts that have been attested by an advocate. So you have to check certain case laws. I don't know. One of my colleagues here, one of you raised that issue. Because let's look at Section 44. 44 talks about execution. First of all, it's on execution. Even from the short title, it's on execution, and it provides that every instrument ought to be executed in accordance with this act. Now, each party consenting to it has to execute it. That is 44.1. It talks about executing, meaning you, Deche, and you, Oduor, you are maybe the purchaser, and you're the purchaser. You're entering into this transaction. You have to execute. That's one. You have to execute. Now, the other thing, under 44.3, it's trying to distinguish between corporate bodies, associations, cooperative societies, saying that if the provision of a relevant applicable law does not provide for the manner in which execution ought to happen, what should happen? The thing that will happen is The thing that will happen is you will sign or execute these documents. Are you saying sign and execute? You will not sign and you will execute these documents in the presence of an advocate of the High Court of Kenya, a magistrate, or a judge, or a notary public. So that one is totally different from what Section 3 and Section 38 is talking about. Because Section 3 and 38 in simple terms is talking about, see if we can get it. Yeah, a contract upon no suit shall be brought upon a contract for the disposition of an interest in land unless the contract upon which the suit is founded is in writing, is signed by all the parties, the signature of which party signing has been attested to by a witness. They don't. Okay, I'll go have to check Section 2. If somebody has their land, do they define who a witness is in that circumstance? By a witness who was present when a contract was signed by such party. So under that provision, it doesn't classify or categorize that, this person who's witnessing has to be an advocate. So in practice, what happens is the people who witness, if you look at wholesale agreements, you will see in the presence of dash advocate, in the presence of dash advocate, they certify, etc. and so forth. But then let's go back to that transfer instrument I was showing you guys. Let me just try and project it again for you to check it out from LRA 33. Then now maybe we can sum it up. Then we go through what I was supposed to take you guys through. LRA 33. This thing has various, it has different provisions. It has different sections or parts. So that's for LRA 33. This is a transfer of interest in land. This is a transfer row, the ID, passport, company number, etc. Consideration, nature of interest to be transferred. Don't worry, you won't be told to draft this thing in an exam. What the most they can do is they can tell you to just give the parts of a transfer instrument or a charge instrument. Now let's start. Execution. Here is execution. Yeah. Execution. This is Section 44. This is Section 44 of the Land Registration Act. Execution. Signed as a deed by the transferors in the presence of name and person of person, name and signature of person certifying. This is a person certifying. Yeah, it doesn't categorize. It doesn't categorize who. It doesn't categorize who can certify and so forth and etc. So they're saying I certify that the above. Okay, this is execution. That is Section 44. We are here hadiapo. That is Section 44. Now execution is totally different, and bear in mind this is an instrument. It's totally different from verification. Now this is verification under Section 45 of the Land Registration Act. Now the issue is who can verify? The person who can verify an instrument, there is a class of persons and it is limited. It is limited. And it's limited to these people in the 4th schedule, listed in the 4th schedule. Yeah. Verification of instruments. Are you seeing, even when you're interpreting statutes, because this is something maybe it may pop up one day in court. When you're interpreting these provisions, reading it as a whole, they've clearly distinguished who can verify. Instruments executed in Kenya can be verified only by a person qualified to practice as an advocate, a judge, magistrate, or kadhi, registrar or the deputy registrar of the High Court, a registrar or a superintendent of prisons and so forth. And then it goes back to what? It goes back to the question we had, the difference between a contract and an instrument, which was answered clearly well and perfectly well. A contract will just lay out the contractual obligations. And we go back to section 38. Provided you've met those conditions in Section 38, you have a valid and enforceable contract. You have a valid and enforceable contract, but the land will not have passed. Now, for the land to have passed, you have to comply. You have to draft a transfer document, and the transfer has to be in compliance with Section 45. It has to be in compliance with Section 44, and it has to be stamped pursuant to Section 6. Lavins.
Hey, how are you?
Oh, fine, thank you. You've joined.
Had a little bit tight evening, but I'm here. So I think just to put this matter to rest, I've been following for the last few seconds. To put this matter to rest, I think I just like briefly in 5 minutes, because for the purposes of perhaps engaging in other things. So I'd like the rest of you to look at Section 3 of the Interpretation and General Provisions Act, Cap 2 of the laws of Kenya. Look exactly what is the spirit of that, statute. What does it mean to execute or to attest? And then, so long as mentioned Section 44 of the LRA, which is advisable as well. And then I'd give you just 3 cases, okay? 3 cases. So at your own free time, at your own convenience, you sit down with yourself and your mind at a meeting and get to summon as much thoughts as you could. So the first case is the Ethan Hiram Irungu versus Merab Anyango Poje. I'll repeat. Ethan is E-T-H-A-N, Hiram, H-I-R-A-M, and then Irongo versus Merab Anyango Poche. Poche is P-O-C-H-E. It's a 2008 Nairobi High Court case delivered on case number 1317 of 2007. So that's the first case. The second case is First Post Homes. First, as it is, First, F-I-R-S-T. Post is P-O-S-T. Homes is H-O-L-M-E-S. First Post Homes Limited versus Johnson. So it's a 1995 volume 4 of the All England Report 355. That's page 355. And then the last case is Goodman versus J. Eben. Goodman is good, and then man, 1-1 versus J. Eben. Eben is E-B-A-N. So 1954, volume 1 of the Queen's Bench, page 550. So if you look at these cases rather, and Section 3 of the Interpretation and General Provisions Act, Cap 2, because that's the statute for interpretation. So look at that statute. What is the language of this statute? Again, Section 3 of the Law of Contract Act, Section 38 of the Land Act, and then Section 44 of the Land Registration Act. I think with that, we just pull this matter to rest. That's also long. I'll pick it up later. Let me do some things here. I'll catch up with you.
Okay, that's fine. That's fine. Thank you for that. Wait, but in those case laws, what was the rationale, Lavins? If you're here. Okay, maybe I may disappear. But when Abusi...
Let me do something urgent. I'm coming. Okay. Oh,
that's fine. That's fine. Edwin, go on.
No, I was hoping that Lavin, where he lives, he could just do the cases again of someone who has gotten the cases clearly, because I've missed out on especially the last case.
So he'll type it down. But I've checked I was just searching the interpretation and general provisions, Section 3. I've not seen anything to do with attestation, but anyways, I'll go check it out. But yeah, that's where you guys will have to go read and focus your time on, and then distinguish between these contracts and Nini. So you've seen, I've highlighted to you the transfer instrument and all. I hope I've shed some light on it. It's an arguable point. One day may find itself in court. We'll submit from there. But yeah, if it's witnessing, personally, I think a contract, anybody